So, very good afternoon, all the participants to this day meeting. So, I would request Kajal Kiranji to please start with the allied laws. Narendra ji has shared the screen.
Okay, sir. Section Section A.
Section A. थोड़ा
Section A
सा
limitation.
आगे कर दीजिए नरेंद्र जी.
हाँ सर.
नहीं और बड़ा अरे और ऊपर कर दीजिए. ऊपर वाले को क्या करना है, नीचे सेक्शन ए से नजर आना चाहिए. हाँ, यहाँ से. यस यस यस. नहीं थोड़ा सा
थोड़ा सा नीचे. हाँ, हो गया.
नाउ इट्स ओके.
Yes, sir.
यस.
Limitation Act 1963. Question number 1. B, Article 137 plus BK Educational. A bank extended a term loan to Company X in January 2019. The loan was repaid in installments. The last installment fell due on 31st March 2020 and was not paid. Excess balance sheet for financial year 2020-21 signed by director on 30th September 2021 showed the outstanding loan as a liability. The bank files a Section 7 IBC application on 15th October 2023. Is the application time barred? A is yes, 3 years from 31st March 2020 is equal to limitation expired on 31st March 2023. No, balance sheet entry dated 30th September 2021 equals to acknowledgement under Section 18 Limitation Act. Fresh 3-year period runs from 30th September 2021. C. Yes, balance sheet acknowledgement is not signed by borrower as an individual. It is signed by director and does not bind the company. D. No, COVID extension by Supreme Court suo motu order covers this period. So answer is section B, that is Section 18 Limitation Act. Balance sheet entry signed by director is equal to acknowledgement binding on company. Fresh 3-year period from 30th September 2021. Application was filed on 15th of October 2023 equals to within 3 years from acknowledgement.
Okay. Case law is asset reconstruction versus Biswal Jiswal.
Jaiswal 2021. So
Okay.
here the concept is given that from where we have to calculate the Limitation Act. So Limitation Act, the answer is B because the directors have signed the acknowledgement. So fresh date starts from that day when the
From the due date.
no due date completes the limitation period is 3 years from 31st March to 2020 equals to limitation period expired 31st March 2023. It's the limitation period, but in between acknowledgement was signed. So whenever the acknowledgement is signed, a fresh date starts from that period. 3 years runs from that is 30th September 2021.
Okay.
That is the reason here.
Okay.
Okay. So here A correct starting point but ignores the section 18 it is giving the answers. Now why A is not here? Correct starting point but ignores the section 18 acknowledgement in the balance sheet dated 30th September 2021 which restarts the clock. So that is what I said. Here A is given that yes, 3 years from 31st March 2020 equals to limitation expired on 31st March 2023 and it is not explaining about it is ignoring section 18 acknowledgement in the balance sheet dated 30th September 2022 which restarts the clock. So that's why this will not be an answer. Then second one is the answer B and C. Why it's not an answer? Because here it's given in C, yes, balance sheet acknowledgement is not signed by borrower as an individual. It is signed by director and does not bind the company. So it is wrong because director signing balance sheet equals to signing on behalf of the company. Company and balance sheet is equal to company's own document. Vishal Jaiswal conclusively settled this. So if director is signing, that will be considered that acknowledgement has started. So director signing balance sheet equals to company is bound. Okay, that's why this is also not the answer. Next, D is also not the answer because in D it's given that no COVID extension by Supreme Court sumoto order covers this period. But in D, it's wrong because COVID extension Supreme Court sumoto writ 3 2020 had specific time frames and does not apply indefinitely or automatically to all cases beyond March 2022.
ओके, बिस्वा जयसवाल 2021 बैलेंस शीट एंट्री इक्वल टू एक्नॉलेजमेंट बाय कंपनी अंडर अंडर सेक्शन 18 डायरेक्टर्स सिग्नेचर ऑन बैलेंस शीट इक्वल टू कंपनीज एक्नॉलेजमेंट phrase 3 years from the date of balance sheet signing application on 15th of October 2023 equal to within 3 years on of 30th September 2021 admitted not time barred.
Okay, so we are not going to read all the options from now because sir is telling that you go through the questions only.
Okay,
So,
madam.
okay. Now the question number 2 is sufficient cause, suits and applications. X files a suit for recovery of money 4 years after the limitation period of 3 years expired. X applies under Section 5 of the Limitation Act for condonation of delay, citing serious illness during the period. The court should condone the delay. Illness is always sufficient cause under Section 5. Condone the delay if satisfied that illness prevented X from filing within limitation. Reject the application. Section 5 applies only to appeals and applications, not to suits. Condone the delay. Courts have inherent power under Section 151 CPC to condone delay in all matters. So answer is C. That is, the court will reject the application because Section 5 applies only to appeals and applications, not to suits. So here it is telling X files a suit and it is asking about the condonation of delay period. That is why this is correct. That is, the court will reject the application because it applies only to appeals and applications and not to the suits.
Okay. येलो वाला पढ़ना है मैम, ट्रैप.
Question number 3.
Okay. Acknowledgement versus part payment.
This is part payment. P owes rupees 10 lakhs to Q since 2019. In 2021, within 3-year limitation from 2019, P calls Q and verbally says, I know I owe you rupees 10 lakhs and will pay soon. Q records this call. In 2022, P makes a payment of rupees 50,000 by NEFT to Q's account with memo towards old dues. In 2025, Q files suit. Is it time barred? Next one answer is, come to the answer.
Answer will be C.
पर ऊपर जाइए आप. हाँ,
जो
आंसर इज
ग्रीन वाला है ना मैम, ग्रीन वाला आंसर है.
yeah, green one is the answer. That is, C is not time barred. NEFT payment in 2022 equals to part payment under section 19. Fresh 3 years from 2022, suit in 2025 is equal to within time. So the answer is section 19, part payment of debt before expiry of limitation equals to fresh period from date of payment. NEFT in 2022 within original 3-year period from 2018 equals to valid part payment. Fresh 3 years from 2022. Suit in 2025 equals to within 3 years from 2022, not time barred. Next one. Question number 4. Section 22 continuing breach. A leases a building to B for 10 years from 1st April 2015. The lease agreement requires B to carry out specified repairs every year. B fails to carry out repairs from 2017 onwards. A files suit for damages for non-repair in 2024. B raises limitation defense. A's suit is barred, barred in part, not barred, not barred. So the answer.
Non-repair is a continuing breach. Phrase limitation accrues dailies.
Okay. The answer is C, Section 22 Limitation Act. Where there is continuing breach of contract, a fresh period of limitation begins at every moment of the continuance of the breach. Non-repair obligation equals to continuous breach is equal to fresh cause of action accrues daily. Suit in 2024 not barred for continuing, not repair. Next question.
PMLA.
Question number 5. PMLA. Mr.
29
A.
E. हम मे 29 E का है मैम डिस्क्वालिफिकेशन.
Now
Okay.
question 5 to question 8. It will go to question number 8. Section 29A subclause D IBC disqualification of resolution applicant.
हाँ.
Mr. A was convicted under Section 138 of the Negotiable Instrument Acts, dishonor of check, and sentenced to imprisonment of 1 year and 6 months in 2019. He has since paid the fine and completed his sentence. In 2024, he submits a resolution plan for Company X under IBC. Is he eligible? First, ineligible. Any criminal conviction disqualifies a person under Section 29A IBC. Eligible. Section 29D 29A subclause D applies only to conviction under what is
Negotiable
PCA?
Instrument Act.
No, it's not taken. It is PCA.
PCA.
1980 is not under Negotiable Instrument Act.
Okay.
He has completed his sentence and paid the fine. Past conviction does not disqualify. Eligible. Section 29A subclause D applies to any conviction with imprisonment of 2 years or more. 1 year, 6 months is below that threshold. Answer will be B. That is Section 29A IBC. The Negotiable Instruments Act 1881 is not listed in the 12th schedule. A conviction under Section 138 Negotiable Instrument Act therefore does not triggers Section 29A subclause C at all, irrespective of sentence length. Structural analysis. No. Structural and limb prescribed punishment threshold scope. D subclause 1 greater than or equal to, if it is greater than or equal to 2 years, then only acts listed in the 12th schedule to ABC, and if it's greater than 7 years, then any other law not in 12th schedule.
हाँ मतलब वो 29(1)D में यही लिखा है मैम.
Maximum prescribed punishment of 2 years, well below the 7 years threshold. Question number 6. Mr. R is appointed as resolution professional of
Repair fault limited.
Limited by NCLT. The COC approves Mr. R's fees at rupees 8 lakhs per month under Regulation 34 of the IBBI or CIRP regulations. After the resolution plan of Triple P Ventures Private Limited is approved by NCLT, Apex Ventures pays Mr. R a further rupees 25 lakhs privately as a success advisory fee for his role in facilitating smooth COC approvals during the process. Mr. R accepts this amount. He does not disclose this payment to IBBI or the COC. Mr. R's criminal exposure under PCA 1988 is for A, none. Mr. R is a private insolvency professional, not a public servant. PCA applies only to government employees and public officials. None. The payment was made after NCLT approval of the resolution plan. Mr. R's statutory function had concluded no offense during tenure. Only under Section 7A PCA against Apex Ventures for offering gratification, Mr. R, even if a public servant had no corrupt intent as he did not solicit the payment. D. Mr. R is exposed to prosecution under Section 7 PCA. He is public servant within Section 2C PCA performing statutory duties under IBC, and the undisclosed payment constitutes gratification other than legal remuneration regardless of whether he solicited it. So your answer is D.
PCA means Prevention of Corruption Act.
So Prevention of Corruption Act. Okay.
Prevention, okay.
Step 1, no. Next question. Huh.
क्वेश्चन नंबर 7 आ गया 7 8
Question number 6. No, we have done it.
ओके
Next,
6
step.
उसके बाद 7 ओके ओके ये पूरा उसका वही है एनालिसिस ही है
Part.
6 7
Yeah, this one.
हाँ यस
PMLA 2002. Section 32A IBC versus Section 71 PMLA. A resolution plan for Emerald Steel Limited is approved by NCLT on 1st April 2024. The approved resolution applicant is an independent company with no prior connection to Emerald Steel's promoters. Before RP approval, the Enforcement Directorate had provisionally attached Emerald Steel's factory under PMLA alleged to be proceeds of crime from a fraud pre 2020. Post RP approval, the ED seeks to continue attachment proceedings. The correct legal position is ED can continue. PMLA attachment is separate from IBC and Section 32A does not extinguish criminal investigations. ED cannot continue. Section 32A IBC extinguishes all criminal liability and attachment proceedings against CD post RP approval if resolution applicant is a genuine third party. ED can continue against the factory specifically since it was attached before CIRP commenced. ED can continue only if the offence relates to the resolution applicant and not to the original management. Answer B. Section 32A IBC. Once RP is approved and there is change of control or management to a genuine third party, resolution applicant not connected to promoters or wrongdoers, corporate debtors liability for pre-CIRP offences ceases and assets cannot be attached or confiscated. PMLA attachment equals to extinguished. Factory is equal to part of CD's assets post resolution plan.
ये सही है मैम ये समझ में आ गया 8 provisional attachment during CIRP
During CIRP. Just a minute. Company Y is undergoing CIRP. RP has taken custody of all assets. On 15th July 2024, the Enforcement Directorate issues a provisional attachment order under Section 5 PMLA attaching Company Y's warehouses. RP challenges this. The correct position is ED's attachment is valid. PMLA has overriding effect and proceeds of crime must be attached regardless of CIRP. ED's attachment is invalid. Section 14 IBC moratorium prohibits any action to take possession or create encumbrance on CD's assets during CIRP. ED's attachment is valid, but RP may apply to NCLT to release the assets for CIRP purposes. ED must first file a claim with the RP. Attachment proceedings are stayed, but claims are preserved. So the here answer is B. Section 14 IBC moratorium prohibits any action to take or recover possession of assets of CD or to create any encumbrance on asset of CD. PMLA provisional attachment equals to action against assets of CD equals to stayed by moratorium. Varsana Ispat NCLAT 2018 plus Rajiv Chakravarti versus ED Delhi High Court 2020. Now, Section C RDDB 1993 plus Arbitration 1996, question number 9 to 12. Question number 9, RDDB Act 1993, Section 21 DRAT appeal 75% deposit. A bank obtains an order from DRT against Company Z for recovery of rupees 5 crore. Company Z files an appeal to DRAT. At the time of filing, Company Z seeks exemption from depositing the mandatory 75% rupees 3.75 crore on grounds of financial hardship. DRAT's power in this context is DRAT has no discretion, 75% deposit is mandatory and not waivable. Appeal cannot be entertained without deposit. DRAT can waive the 75% deposit entirely if it finds genuine financial hardship. DRAT can reduce or waive the 75% deposit on sufficient cause shown. It has discretion to do so. DRAT has no power to hear the appeal of if DRT order is a money decree. Appeal lies to High Court directly. Answer is C. Section 21 RDDB Act appeal to DRAT requires deposit of 75% of amount due. But the proviso to Section 21 gives DRAT discretion to waive or reduce the deposit for reasons to be recorded in writing. Sufficient cause, including financial hardship, can justify reduction. Question number 10. Arbitration Act 1996. Section 16 competence versus NCLT. A financial creditor files a Section 7 IBC application against Company P. Company P opposes admission on the ground that the loan agreement between the parties contains an arbitration clause requiring all disputes to be referred to arbitration. Company P argues that the financial creditor must first go to arbitration. NCLT should stay the Section 7 application and direct parties to arbitration order under Section 8 of Arbitration Act. Admit the Section 7 application. Section 238 IBC overrides the arbitration clause. Insolvency matters are not arbitrable. NCLT has exclusive jurisdiction. Refer to arbitration only the quantum of debt and admit CIRP only after arbitral award. Admit only if financial creditor can prove there was no genuine dispute. That is, apply the Mobilox test to the financial creditor application. Answer is B. Section 238 IBC. IBC prevails over all other laws, including the Arbitration and Conciliation Act. Insolvency proceedings are not arbitrable. NCLT has exclusive jurisdiction under Section 60 subclause 5 IBC. An arbitration clause cannot outset NCLT's jurisdiction in CIRP. Innovative Industries 2018. Question number 11 Arbitration Act 1996, Section 34, challenge to award time limit. An arbitral award is passed on 1st August 2024. The losing party receives a signed copy of the award on 15th August 2024. The party files an application under Section 34 Arbitration and Conciliation Act challenging the award on 20th November 2024. The application is within time, that is 3 months from 15th August 2024 equals to 14th November 2024, but with 30-day condonation equals to 14th December 2024, filed 20th November 2024 equals to within time. Barred 3 months from 15th August 2024 equals to 15th November 2024, filed 20th November 24 equals to beyond 3 months. Barred section 34 applications cannot be condoned. No
Yes,
condonation
continue.
within time. Limitation for section 34 runs from the date of the award 1st August 2024, not from date of receipt 15th August 2024. Answer is section 34 subclause 3. Application must be made within 3 months from the date on which the party making the application had received the arbitral award. The award was received on 15th August 2024. 3 months will be 14th November 2024. But proviso to section 34 subclause 3, court may condone delay up to 30 days. If sufficient cause shown, 15th November plus 30 days equals to 14th December 2024. Filed 20th November 2024 within condoned period, within time if sufficient cause shown. Question number 12, Arbitration Act 1996. Section 17, Tribunals Interim Orders. An arbitration is in progress between X and Y. X fears Y will dispose of assets during the proceedings. X applies to the arbitral tribunal under Section 17, Arbitration and Conciliation Act for an order restraining Y from alienating assets. The tribunal passes the order. Y ignores it. X seeks to enforce the Section 17 order. The correct position is A. X must approach the court for an independent order under Section 9. Section 17 orders cannot be directly enforced. X can enforce the Section 17 order as if it were a decree of a civil court, directly executable. Section 17 order is only advisory. It has no binding force. Y can be cited for contempt, but order not executable as decree. X must convert the Section 7 order to a court order under Section 9 before enforcement. Answer is B. That is post 2015 Amendment Act to Arbitration and Conciliation Act, Section 17 subclause 2. An order made by the arbitral tribunal under Section 17 subclause 1 shall be deemed to be an order made by a civil court and shall be enforceable as such, directly executable without approaching court again.
Surface.
Yeah. Surface Act 2002, Section 13 subclause 2, 60-day notice and Section 13 subclause 3A. 13 3A. A bank classifies a borrower's account as NPA and issues a demand notice under Section 13 subclause 2 Surface Act on 1st June 2024 demanding repayment of rupees 2 crore within 60 days. On 20th June 2024, within 60 days, the borrower sends a representation disputing the NPA classification. The bank does not apply to the representation. On 1st September 2024, after 60 days, the bank takes possession of the mortgage property under Section 13 subclause 4. Is the possession valid? Answer is A, valid. 60 days elapsed from demand notice, bank entitled to proceed under Section 13 subclause 4. Not valid. Borrower made a representation within 60 days. Bank must consider it and give reason for rejection before proceeding under Section 13 subclause 4. Valid. Representations by borrowers are merely informational and do not bind the bank. Not valid. Bank must first approach DRT for permission to take possession even after 60 days. Answer is B. Section 13, that is not valid. Section 13, subclause 3A surface E, where the borrower makes a representation or raises an objection within the 60-day period. The bank shall consider such representation and communicate the reasons for non-acceptance of such objection. Failure to do so before taking Section 13, subclause 4 action equals to action invalid. Section 14 SARFAESI versus Section 14 IBC. A financial institution has obtained a recovery certificate from DRT against Company A. Company A enters CIRP under IBC. The financial institution applies to the district magistrate under Section 14. SARFAESI for assistance is taking possession of Company A's mortgaged factory. The district magistrate should grant the application. Recovery certificate gives priority over CIRP. Grant the application. Section 14 SARFAESI and Section 14 IBC are different provisions. District magistrate acts under SARFAESI. Reject the application. Section 14 IBC moratorium stays any action to take possession of assets of the CD. Section 238 IBC overrides SARFAESI. Hold the application in abeyance under CIRP concludes, then proceed if CD fails to repay. The answer is C, that is reject the application. Section 14 IBC moratorium prohibits any action to take or recover possession of assets of CD. SARFAESI Section 14 District Magistrate Assistance equals to an action to take possession of CD's assets equals to stayed by IBC moratorium. Section 238 IBC equals to IBC overrides SARFAESI. District magistrate cannot grant possession during moratorium. Section 26C, CERSEI registration. A bank creates a mortgage over Company B's factory in favor of itself on 1st January 2020 but fails to register the security interest with CERSEI within the prescribed time. Company B goes into liquidation in 2024. The bank claims status of secured creditor in liquidation. The liquidator's position is bank is a secured creditor. CERSEI registration is directory, not mandatory. Security still valid. Bank is an unsecured creditor. Failure to register with CERSEI means security interest cannot be enforced against liquidator. Bank can still register now post liquidation and claim secured creditor status. Bank is secured creditor for half the claim. CERSEI registration affects only enforcement, not creation of security. So the answer is B, that bank is an unsecured creditor. That is B, Section 26C SARFAESI. Registration of security interest with CERSEI is mandatory. Section 226E, a security interest not registered with CERSEI is unenforceable against a liquidator, receiver or assignee in insolvency. Bank without CERSEI registration equals to unsecured creditor in liquidation. Section MSMED Act 2006, Section 15 to 16, payment and interest. Z Limited, a large company, not an MSME, purchases goods from P Limited, a micro enterprise. No credit period was agreed in writing. Z Limited makes payment 60 days after delivery of goods. P Limited claims interest under MSMED Act. Z Limited argues no agreement equals to no liability for interest. The correct position is P Limited cannot claim interest. No agreement means no obligation to pay within any specific period. B. P Limited can claim interest for the period beyond 45 days from acceptance of goods at 3 times the bank rate. C. P Limited can claim interest only if it has Udyam registration. D. P Limited can claim interest for the period beyond 90 days. MSMED Act gives 90 days when no agreement. So the answer is B, that is P Limited can claim interest for the period beyond 45 days from acceptance of goods at 3 times the bank rate. Explanation is Section 15 MSMED Act. If no agreement on payment period, buyer must pay within 45 days from date of acceptance or deemed acceptance of goods. If paid beyond 45 days, interest accrues from day 46 at 3 times the bank rate, compounded monthly under Section 16. Section 240A IBC MSME exception to Section 29A. Mr. Gupta is the promoter and director of Textiles Private Limited, a small enterprise registered under MSMED Act. Textiles Private Limited goes into CIRP. Mr. Gupta wants to submit a resolution plan. However, Mr. Gupta had given a personal guarantee to the bank, which has been invoked and is now a party to Part 3 proceedings under IBC. Is Mr. Gupta eligible to submit a resolution plan? Not eligible. Section 29A subclause H disqualifies a person who is a guarantor of a CD in CIRP. This applies regardless of MSME status. B is eligible. Section 240A IBC exempts MSME promoters from Section 29AC and 29AH disqualifications. Not eligible. Part 3 proceedings against Mr. Gupta constitute a separate CIRP and trigger Section 29A automatically. D. Eligible only if Mr. Gupta withdraws from the Part 3 proceedings before submitting the plan. So here the answer is B, that is eligible under Section 240A IBC exempts MSME promoters from Section 29AC and 29AH disqualification. That is, the explanation is Section 240A subclause 1 IBC clauses C and H of Section 29A shall not apply to a resolution applicant in respect of MSME corporate debtor. Mr. Gupta is equal to promoter of MSME. Falls within Section 240A exemption. Section 20AH guarantee disqualification equals to does not apply to MSME promoter resolution applicant. Section IRERA plus mediation. Plus DPA plus EPF. Question number 18 to question number 25.
Huh.
Yeah. Question number 18 is RERA 2016 Section 11 subclause 3
Designation.
account usage restriction. Promoter X has a RERA registered Project Alpha, with 200 apartments. He collects the rupees 25 crore from allottees as booking advances and correctly deposits rupees 28 crore, that is 70%, into the designated account maintained for Project Alpha, retaining rupees 12 crore as the free 30%. Subsequently, X withdraws rupees 12 crore from the designated account and uses it to acquire a land parcel for an entirely new and separate project, Project Beta. The remaining rupees 16 crore in the designated account is used for construction of Project Alpha. Allottees of Project Alpha file a complaint before RERA. Which of the following is correct? A. No violation. X correctly deposited 70% into the designated account. The subsequent use for land acquisition is permitted. Head under Section 11 subclause 3. B. No violation. No violation. X has used the funds for land cost, which is expressly permitted under Section 11 subclause 3, the nature of the expenditure is lawful. And C is violation. X withdrew funds from the designated account for project beta, a separate project. Section 11 subclause 3 restricts usage strictly to construction cost and land cost of that specific project. Cross utilization is prohibited. Yeah, question number 19. Section 18, allottees remedies on delay. Developer D was to deliver possession of a flat to allottee A by 31st December 2023 as per the agreement for sale. D fails to deliver possession by that date. In March 2024, D is admitted into CIRP under IBC. A wants to get refund of rupees 50 lakhs paid plus interest, or alternatively to keep the flat and claim compensation for delay. What is A's legal position? A can only seek refund. Possession cannot be granted during CIRP. CIRP extinguishes all contractual rights. B. A has both options under Section 18 RERA, that is refund plus interest or continued possession plus interest for delay. A can exercise either in CIRP as financial creditor. A cannot claim anything in CIRP. RERA has exclusive jurisdiction over all disputes between promoter and allottee. A can only claim as operational creditor in CIRP. Allottees are not financial creditors. Here the answer is B, that is, A has both options under Section 18 RERA and that is CIRP. So the explanation is Section 18 subclause 1 RERA says allottee may seek refund plus interest or continue the allotment and claim interest for delay. Post Pioneer Urban 2019, allottees equals to financial creditors under IBC. A can file claim as financial creditor and exercise either RERA remedy via the CIRP claim process. Question number 20. Section 3, registration threshold. Builder B is constructing a residential complex with 6 apartments in Gurugram, Haryana on a plot of 600 square meters. A home buyer asks whether RERA registration is mandatory. B argues he is exempt from RERA as there are fewer than 8 apartments. The correct position is A, RERA registration not required. Fewer than 8 apartments equals to below threshold. RERA registration required. Plot area exceeds 500 square meters regardless of number of apartments. C. RERA registration not required. The 500 square meter threshold applies to built up area, not plot area. Built up may be within limit. RERA registration required. All residential projects regardless of size must be registered. So the answer is B, that is RERA registration is required. So B explanation is Section 3 RERA registration is required if a area of land proposed to be developed exceeds 500 square meters, or B, number of apartments proposed to be developed exceeds 8. The conditions are disjunctive or either one triggers registration. Plot area equals to 600 square meters, which is greater than 500 square meters, equals to registration mandatory regardless of 6 apartments.
Mediation Act, Section 27, Mediation Settlement Agreement. पढ़ू मैडम मैं? हेलो हेलो
पढ़िए.
हाँ मैडम. A and B underwent mediation under the Mediation Act 2023 and executed the Mediation Settlement Agreement MSA on 1st of October 2024. He alleged that B obtained the MSA by fraud on 5th of February 2025. A want to challenge the MSA. What is his position? A, B, C, D, A. MSA cannot be challenged once executed. That is, it is final and binding like an arbitral award. B. A can challenge the MSA within 90 days of signing, that is by 30th December 2024. But the challenge period has expired. A can challenge the MSA within 2 years from the date of discovery of fraud. Limitation Acts applies. D. A can challenge the MSA at any time by approaching the court where it was registered. Answer is B. A can challenge the MSA within 90 days of signing, that is 30th December 2024. But the challenge period has expired. Explanation to answer B. Uh, Answer B, Mediation Act 2023, Section 28 of MSA Act may be challenged on the ground of fraud, corruption, impersonation, or dispute not fit for mediation. That is within 90 days from the date of MSA. MSA signed 1st of October 2024. 90 days is equal to 30th December 2024. It discovered fraud on 5th of February 2025 after the 90 days challenge period. Challenge is time barred. Question number 22. Commercial Court Act 2025, Section 12A, Mediation Act 2023, Section 12 pre
2000.
pre pre institution mediation versus pre permissive. X Limited and Y Limited have a commercial dispute valued at rupees 2 crores arising from a supply agreement. X Limited fears Y Limited will immediately despite the disputed goods and seek an urgent injunction. X Limited's lawyer advised filing a commercial suit with an injunction application immediately. While Limited's lawyer says they must file complete pre-institution mediation under Section 12A of the Commercial Court Act 2025. Who is correct? E. Y Limited's lawyer is correct, as Section 12A Commercial Court Act makes pre-institution mediation mandatory for all commercial suits without exception. B. X Limited's lawyer is correct. Pre-litigation mediation under the Mediation Act 2023 is pre-massive. No commercial suits require mediation first. X Limited lawyer is correct. Section 12 mandates pre-institution mediation for commercial suits but expressly exempt suit that contemplate urgent intimation relief, urgent interim relief, and injection application to prevent disruption of goods qual- qualifies as urgent interim relief, and Section 12 does not apply. D. Both are wrong. Mediation is mandatory but can expedite the injunction application must await completion of the mediation process. Correct answer is C. Section 12A Commercial Court Act 2025 argues exception. The two status distinguish commercial commercial court act 2025 section 12 mediation act 2023 section 15 applies to commercial dispute of specific value. All all civil and commercial disputes general law. Mediation nature. Mandatory shall not be instituted without pre-institution mediation. Permissive may attempt pre-litigation mediation or argue exception. Yes, exempt suits contemplating urgent interim relief not applicable. Mediation is optional anyway. Section 12. Section 12 is the rules and exception. Question number 23, DPDP Act 2023 data fiduciary IRP's obligation. IP insolvency professionals X is appointed as IRP on company Z. During CIRP, X receive complete employee database of company Z, that is name, salary, Aadhaar number, bank address, bank account addresses of 5,000 employees. X, that is interim professionals, insolvency professionals. X shares this database with a potential resolution applicant to help it assess the workforce. The resolution applicant's consultant uses this data for soliciting employee for another company. Under DPDPD Act 2023 ABCD for option and no violation, that is data sharing in CIRB is permissible, has statutory necessary under DPDP Act. B, X resolution professional may have violated DPDPA by sharing personal data without employee consent for a purpose beyond CIRP need. C, violation of resolution applicant's consultant only. X is not responsible once data is shared in good faith. No violation. Employee of CD are not data principals as they have no contractual relationship with insolvency professionals. Here in this case, answer will be B. X may have violated DPDPA by sharing personal data without employees' consent for a purpose beyond CIRP needs. Answer B. DPDA 2023 X has IRP, data fiduciary for employees' personal data, sharing employee personal data with resolution applicant equal to permitted for legitimate CRP purpose workforce assessment. However, sharing other number and bank account beyond what is strictly necessary. Potential violation of data minimization principle. The purpose limitation principle equal to data set for CRP purpose only. Resolution applicant using it for forcing employee beyond permitted purpose. Means यहाँ पे without the consent of employee data can't be shared. Question number 24. EPF का है exclusion from liquidation estate. यहाँ पे तो स्ट्रेट भी है सेक्शन 36(4) का जो exclusion है. Company K is in liquidation under IBC. The liquidator identify the following assets. A, B, C, D. 4 टाइप की assets है. A, cash in hand, cash in current account 10 crore, 10 crore in current account. B, factory building 50 CR, उसकी जो वैल्यूएशन है 50 CR है. सी, एम्प्लॉइज प्रोविडेंट फंड ट्रस्ट अकाउंट, एम्प्लॉय प्रोविडेंट फंड में जो ट्रस्ट है उसमें 3 crores है विच इज एक्सक्लूडेड असेट्स. और डी, ग्रेजुएटी फंड हेल्ड बाय LIC, दिस इज आल्सो एक्सक्लूडेड assets under section 34 of IBC. The liquidation estate available for distribution to creditor is 65 CR. और 53 का जो है डिस्ट्रीब्यूशन ऑफ asset distribution 65 CR. All assets of CD corporate waste in liquidation estate rupees 63 crore. Only EPF trust, only EPF trust account excluded, gratuity included 60 CR. 60 कैसे हुआ तो कि एम्प्लॉय प्रोविडेंट फंड का 3 crore और उसके बाद ग्रेजुएटी का 2, कैश इन हैंड 10 और 50 फैक्ट्री बिल्डिंग 50 + 10 60 और 5 65. 60 crore. Both EPF Trust Act 3 crore and gratuity fund 2 crore excluded from liquidation estate. Answer C. Straight question है. So D, 62 crore means excluding EPF. Only D में EPF को exclude करी है. Gratuity fund excluded, EPF trust account included has its corporators account. Answer C. Section 36(4)(a)(3) IBC. The liquidation estate shall not include sum due to workmen employee from the provident fund, pension fund and gratuity fund. Both EPF का 3, gratuity का 2 are excluded. Available estate is 60 CR. That is answer. C is 60 crore is true. EPF का है फर्स्ट चार्ज प्लस CIP पीरियड यूज. First charge in a CIP, the RP fails to remit EPF contribution for the CIRP period. Means for the CIRP period, 6 months, 30 lakhs total. The resolution plan is approved, but is silent on this CIRP period. EPF dues. EPF demands payment from the RP personally. The correct position is after CRP, whole responsibility lies with resolution professional. So यहाँ पे आंसर ABCD4 है. ये RP is not a personally liable. CRP period dues and CRP period dues are CRP costs to be paid from the resolution plan proceeds, not from RP's pocket. B. RP is personally liable for CRP period EPF dues if they were not paid during CRP. They are CRP cost and RP's failure to pay personal liability. D. EPF must file a claim as operational creditor for all EPF dues. Pre-CRP and CRP period in the normal CRP process. EPF's claim is time barred. Dues occurred more than 6 years ago during CRP period. Answer is Sunil Kumar Jain. यहाँ पे आंसर बी है. RP is personally liable for CIRP period EPF dues if they were not paid during CIRP. They are CIRP cost and RP's failure to pay personal liability. B. Sunil Kumar Jain versus Sundaresh Bhatt. CIRP period EPF contribution equal to CIRP cost to be paid by RP as part of managing corporate debtor has going concern. RP who fails to remit CIRP period EPF personally responsible. RP cannot say plan is silent. CIRP cost must be paid regardless of plan term. हेलो. यस
Yes,
मैडम हो गया.
अनिंदर जी, ये
अब
वाला तो खत्म हो गया, अब दूसरी वाली करनी है अभी या क्या करना है?
बोलो सर, जिसका मैडम को कन्वीनियंट लगे सर.
मेरे हिसाब
हम
से
तो
थोड़ा कर लो, उसको भी जितना होता है 5 बजे तक कर लो, 5 बजे खत्म कर देना.
okay, sir.
ओके. सर है कि नहीं है सर? ये वाली इसकी बात कर रहे हो सर? हेलो मैडम, ये वाली करनी है.
Next file.
यही है मैम. ये
एक
वाली ही है
अलाइन
ना?
लॉस का और भी है ना?
कौन सा सर?
अरे मैंने बताया तो था, 1 मिनट में देख के बताता हूँ, उसमें लिखा
ये
हुआ है ना मैंने, वो जो ग्रुप में डाला है. एक जनरल लॉस नोट्स, आपने जनरल लॉस किया है ना, तो जनरल लॉस नोट्स कर लो. जनरल लॉस नोट्स भी है ना एक, वो कर लो.
हाँ सर, हाँ सर.
इसको स्टॉप शेयर कर दो, ये स्टॉप
ओके
शेयर
सर.
करके दूसरे वाले शेयर कर दो.
ओके सर. हाँ सर, हाँ सर, हाँ सर.
जनरल लॉस नोट्स करके फाइल है 44
हाँ हाँ.
पेजेस की, वो वाली शेयर कर दो.
ओके सर. हाँ सर. टोटल 44 पेजेस है जनरल लॉज नोट्स। वो सेक्शन 18 ओवरव्यू ऑफ ऑल 18 लॉ कवर्ड, ओवरव्यू ऑफ ऑल 18 लॉज कवर्ड।
आप नीचे चलो ना। हाँ, यहाँ से पढ़ना शुरू करो, ऑब्जेक्ट एंड स्कीम से। हाँ।
मतलब सर थोड़ा 2 मिनट सर आप कर लूंगा सर, 2 मिनट ज्यादा नहीं सर। मतलब इसमें ऐसा है कि जो भी एडिशनल अलाइड लो के 11 लॉस है, इसकी
हाँ
उसकी पूरी समरी इसमें जो 41
हाँ, सब
पेजेस।
मोटा मोटा समझ गया।
ओके सर, इन समरी फॉर्म इट विल बी इंक्लूडेड इन दिस 44 पेजेस,
हम्म
ऐसा ही। हाँ ठीक है सर, पूरा पढ़ाई कर लेते हैं सर, कोई इतना नहीं है सर, कर
हम्म
लेते
हम्म
हैं सर।
हम्म,
ओके।
हाँ
लो वन, पहले तो मैम पहले हमें ये वाला करना था, उसके बाद क्वेश्चन करने थे, हम उल्टा गए सर। लो वन लिमिटेशन एक्ट दो 1963 object and schemes. The Limitation Act 1963 prescribed the time limit within which legal proceedings must be initiated. The object is to fold, protect, defend
Defendants.
dependents from slate claims, and ensure judicial certainty. Law require dispute to be brought into a definite time so that court can decide cases based on reliable.
काजल जी, पढ़ प्लीज।
Yes, sir.
हाँ।
Law requires disputes to be brought within a definite time so that courts can decide cases based on reliable and fresh evidence. After the period expires, the right to sue is extinguished, though the underlying right or debt may survive as a moral obligation. Key principle: limitation extinguishes the remedy, not the right. A time barred debt still exists as a natural obligation. It cannot be enforced in court. This is why Section 25 Subclause 3 ICA promise to pay time barred debt and Section 18 of Limitation Act acknowledgement are critically important. Schedule of the Limitation Act. Key articles for lie. Article 36 recovery of money lent under written instrument. Example loan agreement. Period is for 3 years. Starting point section 2J and right to sue accrues. Date of loan or demand as per instrument. Article 37 money payable under judgment. The period is for 12 years and time is date of judgment. Section Article 64 recovery of possession of immovable property. The period is for 12 years and date of dispossession occurred. Article 113 any suit for which no period prescribed. Period is for 3 years when right to sue first accrues. Article 137 any other application residuary includes IBC applications. Section 9 Section 7 Section 9 the period is 3 years when right to apply first accrues. Limitation for IBC applications. Article 137 the Supreme Court in BK Educational Services Private Limited versus Parag Gupta and Associates 2018 17 SCC 673 definitively held that the Limitation Act 1963 applies to proceedings under IBC 2016. The applicable article for Section 7 and Section 9 applications equals to Article 137 residuary period of 3 years from the date the right to apply first accrues. When does right to apply first accrue? Section 7 financial creditor application date of default of the financial debt, not date of demand or notice. Section 9 operational creditor application date of default of the operational debt, not date of CIRP notice under Section 8. Once default crystallized, 3 years clock starts. If financial creditor or operational creditor files after 3 years without acknowledgement, application is barred.
एक
BK Educational Services Private Limited versus Parag Gupta and Associates. Held Limitation Act 1963 applies to IBC proceedings. IBC does not exclude the Limitation Act. Section 7 or Section 9 applications must must be filed within 3 years from the date of default. The trigger is the date the right to sue first accrues, that is the date of default, not date of demand or filing of claim. IBC or lie relevance must know for lie. IRP or RP must check limitation for each creditor's claim. Claims barred by limitation as on CIRP commencement date equals to not admitted. This prevents reopening of old stale claims through CIRP. Exclusion of time, section 5. Any appeal or any application may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period. Sufficient cause, court has discretion. Illness, natural calamity, fraud, mistake of legal advice may constitute sufficient cause. However, section 5 does not apply to suits, only to appeals and applications. Acknowledgement, section 18. Section 18. Where before the expiration of the prescribed period for a suit or application in respect of any property or right, an acknowledgement of liability in respect of such property or right has been made in writing, signed by the party against whom such property or right is claimed, a fresh period of limitation shall be computed from the time when the acknowledgement was so made. Requirements for section 18 acknowledgement in writing: it should be in writing. Oral acknowledgement is insufficient. Signed by the parties liable or his agent. Must be made before expiry of limitation period. Cannot revive already time barred debt order under section 18. Section 325 subclause 3 ICA for that. Must acknowledge the specific liability, not just mention of debt generally. Effect: fresh period of limitation starts from the date of acknowledgement. Asset Reconstruction Company India Limited versus Bishal Jaiswal. Held question whether an entry in balance sheet or annual report of a company amounts to acknowledgement under Section 18 Limitation Act. IBC or lie relevance: balance sheet entry showing a debt as liability equals to acknowledgement under section 18, triggers fresh 3-year limitation. Directors who sign balance sheet sign the acknowledgement. This is crucial for determining admissibility of claims in CIRP. Payment as acknowledgement, section 19. Section 19, where payment on account of a principal or interest in respect of any debt has been made before the expiration of the prescribed period by the person liable to pay the debt, a fresh period of limitation shall be computed from the time when the payment was made. Part payment equals to debt equals to fresh limitation. The payment must be made by the debtor, not third party, and must be on account of the specific debt. IBC Connect, IRP verifying claims. Check A, is the claim time barred as on CIRP? Commencement date. B, is there a balance sheet acknowledgement? Section 18 extending limitation. C, was there a part payment? Section 19 within 3 years. Is there a written promise to pay? Section 25 subclause 3 ICA. If all are absent and 3 years elapsed from default, claim must be rejected as time barred. Section 22, continuing breach or tort. Where a suit is for continuous breach of contract or continuous tort, fresh limitation accrues at every moment during continuance, relevant for ongoing contractual breaches by corporate debtor. Section 18 continues. Law Prevention of Corruption Act 1988. Law to Prevention of Corruption Act 1988. Why is Prevention of Corruption Act is in lie syllabus? The Prevention of Corruption Act 1988 appears in the lie syllabus because IBC Connect section 29A subclause D, IBCC, a person convicted of any offense punishable under uh, Prevention of Corruption Act 1988 is ineligible to be a resolution applicant. This is the primary reason that Prevention of Corruption Act is tested in lie. An insolvency professional must know
What connections?
functions involving public interest and large financial assets under the Insolvency and Bankruptcy Code 2016, and misuse of such powers may attract anti-corruption liability. Insolvency professionals handle public interest assets. During CIRP or liquidation, the resolution professional or liquidator takes the control of assets of the corporate debtor, conducts resolution plan bidding, handles claims of financial and operational creditors, deals with banks, government dues, and public money. Because these activities after public financial interest, corruption risks as exist. Therefore, knowledge of the Prevention of Corruption Act is essential. RP may be treated as a public servant. Under Section 2, Subclause C of the Prevention of Corruption Act, a public servant includes persons performing public duty under a statute. Resolution professionals act under authority of IBC, operate under supervision of NCLT, exercise control over assets belonging to creditors. Because of these features, courts have observed that RP performs public duties and therefore actions like bribery or illegal gratification may attract PCA provisions. Hence, the LIE syllabus includes the PCA so that professionals understand criminal liability exposure. Insolvency processes are high risk for corruption. Certain stages of CIRP involve significant financial discretion. For example, evaluation of resolution plans, conduct of expression of interest or bidding process, appointment of valuers and professionals, admission or rejection of claims. Improper influence or bribery in such decisions could not could fall under offenses like bribe taking, abuse of official position, criminal misconduct, which are offenses under the Prevention of Corruption Act. Professionals, ethics, and compliance. The Insolvency and Bankruptcy Board of India requires insolvency professionals to follow strict standards. Code of conduct for insolvency professionals, integrity and independence, avoidance of conflict of interest, understanding the PCA helps ensure compliance with anti-corruption norms. Link with Section 233 IBC protection. Section 233 of the IBC provides protection for actions done in good faith. However, corrupt acts are not protected. PCA offenses override the immunity. Therefore, candidates must understand the boundary between good faith decisions and criminal misconduct. In definition of public servant, Section 2, Prevention of Corruption Act. Public servant under PCA 1988 is defined widely, incorporating IPC Section 21 categories and adding more. Any person in the service or pay of the central or state government, any person in the service or pay of a local authority, any person in the service or pay of a corporation established by central or state act, any judge, including a person empowered by law to discharge adjudicatory functions, any member of armed forces, any person authorized by court to perform public duty, example, receiver, official, liquidator. Any person who holds an office by virtue of which he is authorized or required to perform any public duty. IP is not a public servant under PCA. Confirmed, however, the adjudicating authority, NCLT, DRT, and IBBI officers are public servant. Key IBBI DC order in Mr. Ravish Srinivasan, IBBI DC 2021 IBBI held IP occupies a position of public trust. Contention against public servant status. IP is a private professional licensed by IBBI, not appointed by the state. No salary from consolidated fund. IPC Section 21 does not include IPs in its enumerated categories. Prevention of Corruption Act 1988 Section 2 Subclause C defines public servant by reference to IPC Section 21. IPs not explicitly included. Insolvency professional or resolution professional is a statutory officer performing public functions under the IBC, while Section 233 protects acts done in good faith. It does not provide immunity against fraud, corruption, or actions beyond statutory authority, and such conduct may attract liability under the Prevention of Corruption Act. Present position is not judicially settled at Supreme Court level, high courts are divided. Practically, criminal complaints against IPs under PC Act have been entertained by courts, making this a live risk. Key offences. Section 7 to 16. Section 5 and 7 offense public servant accepting or agreeing to accept gratification or bribe for doing or not doing official act. Punishment is minimum of for 3 years and maximum for 7 years plus fine. Section 7A added by 2018 amendment giving or promising undue advantage to public servant. Minimum 3 years, maximum 7 years plus fine. Section 11 public servant obtaining valuable thing without adequate consideration from person having interest in proceedings. Punishment is for 6 months to 5 years plus fine. Section 12 abatement of office offences under section 7 and section 11 same punishment as principal offender. Section 13 criminal misconduct by public servant 3 to 7 years plus fine. Section 14 habitual commission of offences 5 to 10 years plus fine. Section 15 attempt to commit offence under section 13 subclause 1 subclause A up to 3 years. Section 16 property in name of personal guarantor or relative presumed to be bribe if disproportionate, and the punishment is under section 13. Section 29A IBC eligibility of resolution applicant. Section 29A lists persons ineligible to submit a resolution plan. Clause C specifically disqualifies a person who has been convicted for any offence punishable with imprisonment for 2 years or more, including offences under PCA 1988. The IBBI model paper and like questions test. Which of the following disqualifies a resolution applicant under section 29A? PCA conviction is a standard option. The 2-year imprisonment threshold is the test. Arun Kumar Jagatramka versus Jindal Steel and Power Limited. Held. Person convicted for market manipulation SEBI whether eligible to submit resolution plan. IBC or lie relevance. Person specifically listed in section 29A or those who have convicted under specified laws including PCA equals to ineligible. Object of section 29A is equal to prevent defaulting promoters and convicted persons from taking back control of CD at a discount. Section 29A construed strictly. Section 18 continues. Law 3 Prevention of Money Laundering Act 2002. Law 3 Prevention of Money Laundering Act 2002, that is PMLA. Object and framework. PMLA aims to prevent money laundering and provide for confiscation and forfeiture of property derived from or involved in money laundering. It has significant interface with IBC primarily regarding the status of attached properties of a corporate debtor during CIRP. Key definition. Section 2 PMLA. Money laundering. Section 3 whosoever directly or indirectly attempts to indulge or knowingly assist in any process or activity connected with proceeds of crime is guilty of money laundering. Proceeds of crime. Section 2 subclause 1 subclause U any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. Attachment. Section 2, subclause 1, subclause D. Prohibition of transfer, conversion, disposition, or movement of property by an order. Scheduled offense. Section 2, subclause 1, subclause Y. Offenses listed in the schedule to PMLA include IPC, NDPS, FEMA, Companies Act, IBC, etc. Reporting entity. Section 2, subclause 1, subclause 2, WA, a banking company, financial institution, intermediary, or a person carrying on designated non-financial business as notified. Beneficial owner. Section 2, subclause 1, subclause FA individual who ultimately owns or controls a client or person on whose behalf transaction is conducted. Offense of money laundering, section 3 and 4. Section 3, whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use, and projecting or claiming it as untainted property, shall be guilty of offense of money laundering. Section 4, whoever commits the offense of money laundering shall be punishable with rigorous imprisonment for a term which shall not be less than 3 years, but which may extend to 7 years, and shall also be liable to fine. Attachment and confiscation. Section 5 to 8. Provisional attachment. Director or deputy director PMLA can provisionally attach property believed to be proceeds of crime. Period is 180 days, extended by adjudicating authority of the PMLA. Adjudicating authority and independent adjudicating authority under PMLA to confirm or release provisional attachments. Appeals against adjudicating authority of PMLA order lie to appellate tribunal for PMLA. Confiscation. After adjudicating authority order confirming attachment, property becomes forfeit to central government.
Let's stop here.
Okay,
Okay,
sir.
sir.
And we can
Yes.
continue in the next class.
Yes, sir.
Okay.
Okay, thank you, sir.
Okay.
Thank you,